Chapter 3, Negotiability. Section 13. Meaning of term. The term negotiability implies a transferable quality in the instrument to which it is applied. It is that quality of bills of exchange and promissory notes which renders them transferable from one person to another, and by possessing which they are emphatically termed negotiable paper. Negotiability in the law merchant is the property whereby a bill, note or check passes or may pass from hand to hand like money, so as to give the holder in due course the right to hold the instrument and collect the sum payable, for himself, free from defenses. The negotiable instruments law provides, an instrument is negotiated when it is transferred from one person to another in such manner as to constitute the transferee the holder thereof. If payable to bearer, it is negotiated by delivery; if a payable to order, it is negotiated by the endorsement of the holder completed by delivery. An instrument negotiable in its origin continues to be negotiable until it has been restrictively endorsed or discharged by payment or otherwise. Section 14. Origin of negotiability. Originally all instruments, including bills of exchange, promissory notes and bank checks, were non-negotiable in the sense that the maker could, when asked for payment, deduct from the amount due on the instrument any just claim that he had against the original owner. Such claim was termed a counterclaim, or set off. In the revival of commerce in Italy, in the 11th century, merchants and traders, feeling the need of a commercial instrument, similar to a bank bill that could be used in barter and trade and commercial transactions, and realizing that no such instrument could be passed from hand to hand or sold readily, no matter how good the financial standing of the maker was, if he, the maker, could always insist on adjusting accounts with the original owner, adopted a custom later known as the law merchant, under which notes, checks, drafts, and bills of exchange, drawn in certain prescribed forms, and in the hands of a bona fide purchaser, could be enforced to their full extent against the maker, regardless of certain defenses or counterclaims that the maker might have against the original holder. Such instruments were negotiable, and such was the origin of negotiability. In England, embarrassments arose in the application of the common law to these forms of contract, and it was only after a long struggle that the courts engrafted upon the common law the law merchant, by which the parties to bills and notes were put upon a footing entirely different from that of parties to other contracts. The customs and usages of merchants as to negotiability of bills of exchange finally came to be recognized and enforced by the courts, but were not put upon a firm basis until they received the sanction of Parliament. Promissory notes were first recognized by the courts as negotiable, and later they were refused that recognition. Their negotiability was at last established in 1705 by a statute passed by Parliament. The principles of this statute have been followed in a general way by the various states of this country and embodied in statutes. Section 15. Distinction between assignability and negotiability. Assignability is a more comprehensive term than negotiability. Assignability pertains to contracts in general, while negotiability pertains to only a special class of contracts. Property, rights in property and other valuable rights evidenced by a contract are transferred by assignment. The rights evidenced or created by ordinary contractual obligations are usually a kind of property, having in themselves a value measured in law by the damages assessable upon their breach. This property may at this stage of the law pass from person to person just as any other property does. But there are well-settled rules governing such transfer, which are the outgrowth and mingling of early doctrines of the courts of common law and of equity. The primitive view was that in contracts of this nature the assignee only could sue upon the contract. This was based upon the ground that the contract created a personal obligation between the creditor and debtor. This doctrine has been greatly modified in the various states by statutes which declare that every action must be prosecuted by the real party in interest. Title to any property or rights in property cannot be completely passed, as to the debtor, by assignment without notice to him. The result of this rule is that if the debtor performs his contract to the original creditor without any notice of the assignment, he is discharged. These are not the rules as to negotiability. The person who takes an instrument by endorsement takes it free from all equities, while a person who takes an instrument by assignment takes it subject to the equities incident to it. This is the distinguishing feature between assignability and negotiability. Negotiability is applied to instruments instruments which contain a promise to pay money. These instruments embodying a promise to pay money may be either negotiable or non-negotiable. In order to be negotiable under the law merchant, they must contain some words indicative of negotiability. The usual words employed to denote this quality are to or order, to the order of a or to bearer. Thus then the material difference between a non-negotiable instrument and a negotiable instrument is that the party to a non-negotiable instrument who has agreed to pay money or property under it, may, when the money or consideration is demanded by a purchaser, set off against it any claims that he has against the original owner, which he could have set off if it had not been assigned, while the bona fide purchaser, before maturity, of a negotiable instrument can enforce it for its full amount against the maker, regardless of any counterclaim or other equities that the maker has against the original owner. Section 16. Purpose of negotiability. The primary purpose of negotiability is to allow bills and notes the effect which money, in the form of government bills or notes, supplies in the commercial world. A man does not always have property or valuable property rights which he can turn into cash at any moment. These things, however, measure his credit, and he avails himself of this credit by executing his note to his debtor, who in turn endorses this to a third person. These men in this way without cash in hand are enabled by means of credit to conduct and carry to completion business and commercial enterprises. The sole purpose of negotiability then is to allow men of undoubted credit to carry on a business enterprise upon their promissory notes, knowing that other businessmen will treat these promises as cash. Furthermore, the purpose of negotiability is to allow bills and notes to go from hand to hand in the commercial markets and to take the part of money in commercial transactions. Section 17. Payment by negotiable instrument. In the absence of an agreement, either express or implied, a negotiable instrument is not an absolute and unconditional payment of the debt and a discharge of the original obligation. Thus it has been held that the debtor's own note given for a precedent or contemporary debt is conditional payment. If, however, a new note is given in renewal of a former note and for a less amount, it will be considered as a satisfaction of the prior note, as all differences are presumed to have been adjusted when the new note was given. Nor is a new note executed by only a part of the original promises generally to be considered as payment of the prior note in the absence of any agreement to that effect. In case the bill or note of a third person is given in payment of a precedent debt, the payment is generally held to be conditional, but when the stranger's note is payable to bearer or has been endorsed in blank by a prior holder so that it may be transferred without endorsement, it is then considered as absolute payment when given for a contemporaneous debt. But it is only as conditional payment when payable to order and can be transferred only by endorsement. A note is not discharged by giving a new note which proves invalid. Thus the original note is not discharged even though it is surrendered and a new note is accepted in payment without knowledge that the new note is a forgery. It is not necessary that the old note be surrendered or cancelled before a new note can operate as payment.